Good morning. Welcome to another session of the 5th District Court of Appeal. As our marshal indicated, I am Judge Lambert. I'm presiding this morning. Let me introduce the panel. To my right and your left is Judge Jay Cohen. That's right, okay. To my left and then your right is Judge John Jordan. He is sitting with us this week from Osceola County, Circuit Judge, Osceola, Orange County. And we appreciate his help with us today and this past Tuesday. We have 4 cases this morning, 1 criminal, 3 civil, 15 minutes for the criminal case on each side and 20 minutes for the civil cases. If you have a phone or other electronic device, if you could please turn it into the mute or off position so it doesn't distract the attorneys when they're arguing, we'd certainly appreciate it. I will reserve 5 minutes rebuttal time for the appellants. If you would like something different, let me know. With that being said, the first case on our docket is case 14-4595, State of Florida versus Thomas Christopher Pullen. Counsel, whenever you're ready.
Good morning. May it please the court, counsel. My name is Kelly Neal, and I'm here on behalf of the state of Florida in this appeal. The operative facts, as found by the trial court, are this man was not in custody, he was not interrogated, and he reinitiated any contact with the police officers. So it's our position that the trial court erred in suppressing his statement based on the fact that he should have been read his Miranda rights. And if the court doesn't have any further questions, I'll save the rest of my time for rebuttal.
So let me ask you this. Law enforcement, not accusing this, but they say, you know, let's try this tact with the guy. When he tells us he's lawyered up, let's act disinterested and leave. And then when he questions us, we'll go back and talk to him. Do you still think he's not in custody at that time?
Yes.
And well, I mean, address the argument then by the underlying defendant then that, you know, this is essentially a custody situation in the sense that once he has invoked his right to counsel, there should be no further inquiry unless he's Mirandized.
The trial court found he was not in custody.
Okay, but then once he had invoked, he wanted counsel, he should have been Mirandized.
Miranda only applies to custodial interrogations.
So, again, this thing of leaving and we'll talk to you later, and then they follow up that you don't think that they should have given him any further warnings at that time.
It was not required. Miranda rights are a procedural safeguard applicable only to custodial interrogations, which this was not. Thank you.
All right. You have 13 minutes and 23 seconds if you'd like. Rebuttal. All right, counsel.
Good morning. May it please the court, counsel. Flynn Burdish appearing on behalf of Thomas Pullen, the appellee in this case. And yes, Judge, Ms. Neiman is correct. This is not an issue of custodial interrogation.
It's not a Sixth Amendment case, correct?
No, it is not a Sixth Amendment case either, no, because as you're aware, the Sixth Amendment is offense specific. We are arguing this, as Judge Toner argued, and again, there's a presumptive correctness in his ruling, is that...
On his legal interpretation?
Yes, sir.
You think so?
I do believe so, yes.
Why is his legal interpretation entitled to deference? His factual determinations are entitled to deference, but not his legal analysis.
Well, I believe in his analysis, what Judge Toner said, and we agree with it, is the fact that despite this not being a custodial interrogation, his argument and our argument was that these are procedural safeguards. And despite this, even though Miranda applies to custodial interrogation, Miranda must be read prior to any questioning in the custodial interrogation. In this particular case...
It wasn't a custodial interrogation.
Correct. But in this particular case, our argument is once Mr. Pullen invoked his right to counsel, and law enforcement then acknowledged his right to counsel and said they were leaving, and then he reinitiated, that's when that triggered the procedural safeguards of Miranda.
Was he in
So
custody?
just saying lawyer requires Miranda?
No, not necessarily, but in the facts of this case, the day before, on May 7th, law enforcement interviewed Mr. Pullen. He gave a statement, he denied any involvement in this case, and then said we would re-interview you and we'll meet you the next day. On that next day, when Mr. Pullen did not appear for the interview, law enforcement actively went to look for him. When they found him at his shop, and it's again, not custody, but when they found him at his shop, Mr. Pullen said to them, "My family told me not to speak with you," and handed the detective back the detective's card with the lawyer's name on the back. Law enforcement acknowledged at that point, "We know your lawyer, and we will leave, but we'll contact him to speak with you later." At that point, that acknowledgement shows that they've accepted his invocation. Upon reinitiation...
Supposed to do.
Right. But then when he reinitiated is when it is, with Judge Toner, in our opinion, is that's when the procedural safeguards kick in.
Right, so they're supposed to say, "Oh, no, 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 don't talk to us."
No, what they're supposed to say is, "Okay, before you speak with us, you've asked for your attorney. Do you still want to talk to your attorney?" It doesn't have to be a full reading of Miranda. There has to be some type of reconciliation of the fact that I've asked for a lawyer, and we're going to say, "Okay, do you still want to talk to us without your lawyer present?" And this is different than just a...
And what case do you cite for that proposition?
I am actually looking at one of the cases I would cite to, and unfortunately, there's no cases on point. I believe this is a case in first impression. There's no cases of non-custodial invocations of a right to counsel. So I don't have a case to cite to. We are citing to cases such as the Welch case, which talks about reinitiation, and I understand that's after a custodial interrogation when Miranda is read. But again, the judge found that this was not custody, but felt, in his opinion, that because of the invocation and reinitiation, law enforcement needed to make it clear that a lawyer could be made available or we could wait, especially when law enforcement said...
But that effectively converts it into a custodial interrogation.
It does at that point, because now whether it be a statement they want or anything looking for incriminating responses, they know that he's a suspect in this case. They have probable cause to arrest him at that point. He is the sole suspect in this case. Arrest is imminent. Law enforcement stated they wanted to get a statement from this person. And so they used their tactics in a way to get a statement.
What if he wasn't a suspect in the case and he just was a person that, let's say it was a burglary or a CVS, and he happened to be there and they wanted to talk to him because maybe he saw something, and it turned, and then you have the same scenario. It's not custodial. He says, "Oh, by the way, I have a lawyer for all my things." Fine, and he decides to reinitiate, and they said, "Well, just give us a written statement as to what you observed," and he does, and then it incriminates himself. It's not custodial. He wasn't a suspect. No Miranda was read. Are you still saying in that scenario that Miranda should have been given because he made a statement, that a blanket statement, "Oh, I have a family lawyer that I discuss everything with, any legal issues"?
In that case, I would say it differs a little bit because this is a sole suspect, but I would still, but I would still make...
They've made the facts up.
Right, but I would still make the same argument as at that time of invocation, that they should still, law enforcement should still have the duty to at least ask about the lawyer.
So we should have a general rule that anytime somebody says, "Oh, by the way, I have a lawyer," that then implicates Miranda in some respect?
No, not all the time, because in one of the cases that the state cites, which is the Bobby versus Dixon case, that's a chance encounter where the detective sees this person who may be a suspect in another offense, reads him Miranda before talking to him, and he asks for a lawyer, and then 5 days later, they arrest him on a separate charge, and then they don't read him Miranda, and then they throw out the forgery case, but then they allow the confession in regards to the murder case because they did Mirandize him later. There's also a case that's cited in there, actually I found, which is the Pardon. It's Pardon versus State. It's found at 930 Southern 2nd, 700. I found it yesterday, and it talks about...
Did you do a supplemental authority?
No, I didn't. I apologize for that.
Can't talk about it at oral argument.
Well,
Now, you can, after argument, you can go ahead and do a notice of supplemental authority with that case cited.
Okay, thank you. But in part of the state's brief, they mention about this anticipatory invocation. And when you look at anticipatory invocation, it talks about the cases cited were McNeil versus Wisconsin and the Montejo case, which actually talk about the Sixth Amendment invocation when it deals with forms that people can fill out at either a first appearance or a preliminary hearing. And the court said that you can't anticipatorily invoke your right to counsel for a Sixth Amendment issue because, again, that is offense-specific and it not necessarily questioning something else. However, in this particular case, it's not anticipatory because they've already spoken to him. He went home that night, talked to his family, they told him to ask for a lawyer, and he asked for a lawyer the next day. So in that particular case, I would say that this invocation does trigger the procedural safeguards that the Fifth Amendment and Miranda require.
What societal interest is being protected with that rule of law?
The societal interest being protected would be that of the right to a person to speak with a lawyer upon questioning by law enforcement.
They honored that. He invoked his right to counsel, and they did what they were supposed to do. They stopped questioning him, and then they're leaving. And he reinitiates contact with them. What, I'm trying to understand what.
It would be the fact that when a person invokes their right to counsel, the societal interest is the fact that they should have the right to speak with their attorney. They are a suspect in a crime.
He had that right. He gave up that right.
But upon reinitiation, there should still be a...
So you think there ought to be a rule of law that protects him against himself?
Yes, which is what Miranda does do. It does protect you against self-incrimination, as what the Fifth Amendment applies. It's an interesting case.
Of course, that's custodial.
Right. But again, it's the triggering of the procedural safeguards.
And it's the coercion, and that's what we're talking about with Miranda. You're in custody, you've got police officers, there's just that aura of the police authority, whereas it doesn't seem that is present in these circumstances.
Well, I believe there is, given the fact that they had talked to him the day before. This wasn't a chance encounter. This was a second interview where he did not go to the interview that was scheduled, either by the decision from his family that he had a lawyer, that it wouldn't be in his best interest, but the fact that the law enforcement actually went out of their way to find him because he missed the interview, I think changes that whole dynamic. And just as a side note, after the confession was given, law enforcement actually did contact his lawyer and say, by the way, we got a confession from your guy. So there's that extra step that falls after, is they went forward to finally contact the lawyer and say, hey, your guy confessed.
What difference does that make?
Well, I think it shows that they had known that he invoked his right to counsel.
He did. They knew that. They told him. He told them, this is the name of my lawyer.
Right, but they actively contacted the attorney and let him know that.
What difference does that make?
I just think it's more of a difference of the fact, it shows that they should have acknowledged once he reinitiated that, hey, do you want to speak to your lawyer or not, because they did.
All right.
So I would say that I would ask that the decision of Judge Toner based on that be affirmed. Thank you.
Thank you, Counsel.
Thank you, Counsel.
Just quickly, there is a case right on point, and it's out of this court. It's called Perez-Ortiz, and it's at 954 Southern 2nd, 1256. And it basically says what I've argued, that Miranda doesn't apply to non-custodial situations. So I would ask this court to reverse the order of the trial court. Thank you.
Thank you.